Hello, my name is Andrew Nyamayaro. Thank you so much for joining me on this day, the 6th of May 2025. I'm streaming live on Facebook, TikTok, and YouTube, and it's wonderful to have you here. Please like and subscribe to our channels so that you can receive more information about the information that we send about and about more videos that we do. Today we have got an interesting topic that we are discussing, and this is the topic about settlement after 5 years on the skilled worker visa. I've been receiving a lot of questions from a number of people in relation to this topic, where people want to know more about what happens after spending 5 years in the UK on the skilled worker visa. As you would be aware, most people came to the United Kingdom on the skilled worker visa as carers under the old SOC code 6145 and SOC code 6146. Some of them are now over 3 years, 4 years, and some will be getting into the period of thinking of indefinite leave to remain or a settlement, which will be, for most people now, maybe around 4 years, the earliest called to come to the UK. So it is important that we make conversations about this topic on indefinite leave to remain or settlement. So the pathway to indefinite leave to remain for skilled workers is one which is quite crucial. And the eligibility criteria is as follows. Someone needs to have accrued 5 years of residing in the United Kingdom under the skilled worker visa. And the employment should have been ongoing employment with a sponsor or a licensed sponsor. You need to be meeting the threshold. For those that are on the health and social care visa, the threshold as we speak now for the 2025 salary, we are speaking of £25,000 or £12.82 per hour. Previously, it was on £11.90, I think, and then previously it was on £10.10. So those are the figures that we'll be looking at if you're going to get indefinite leave to remain on the basis of skilled worker visa. The rest of the people, we are looking at around £37,700, let's say about £39,000 as income, or the ongoing rate, whichever of the two is higher. You also need to have passed the knowledge of life in the UK test, and you also need to have passed the English language proficiency. We know that most people, when they came to the UK, they would have done the B1 certificate, and some would have done 4 components, some different components, and so forth. But it is important for you to review and verify that you have got the English proficiency test and you've passed it. One other important point is the good character. You need to satisfy the good character requirement, and I'll speak on this one later on as we proceed. You also need to be careful about the time that you spend outside the UK, and you should not exceed the permitted absences from the United Kingdom. As I have said, the salary requirement are as follows. The standard threshold is £38,700 per year or going rate, whichever is the higher. The exceptions are the health and social care visa, which is currently 25,000 or £12.82. Jobs that are on the immigration salary list, they are on the £30,960 or the going rate. And if the first certificate of sponsorship was issued before 4 April 2024, we are speaking of 29,000 per year or the lower going rate. One of the questions that I get asked a lot is about the absences from the UK, particularly for dependents. We know that some of the dependents have been living in between the countries, between the United Kingdom and their home country. So you will find that the dependents are spending some time in the United Kingdom, and they're also spending some time in their home country. So the permitted absences are as follows: no more than 180 days in any 12-month period. So for every 12 months, you should not spend more than 180 days, not pounds, outside the country. And the calculation is the rolling 12 months during the 5-year qualifying period. The only exceptions that might be accepted by the Home Office is where someone has got a serious illness or injury, or where there is a conflict or natural disaster, or where there is pandemic related travel restrictions. Remember, like what happened in 2020 and the periods that followed after 2021 and so forth when there was the pandemic. Going on to the exams or tests that you need to do, the first one would be the Life in the UK. And this is mandatory for everyone that is between the age of 18 and 64. You need to pass the Life in the UK. And again, you also need to pass the Life in the English test. Um, CEFR level B1 or above, proven by approved English test, degree taught in English, or if you are coming from a country that has got the majority of English speaking people as recognized by the Home Office. So if you've got a degree that is taught in English, you will need to have it checked and verified by the ECCTIS, which was previously called NARIC before. So Life in the UK test and the English test, those are the requirements that you need to meet as well if you're going to qualify for indefinite leave to remain. As for the good character, the Home Office will assess, and they've got access to information on criminal activity, county court judgments, and they've got access to a number of government departments and agencies where they can get a lot of information. So the Home Office will assess for criminal convictions, immigration offences, financial soundness, if you've got any CCJs, or if you've been declared bankrupt, or if you've got an IVA, and so forth. And if you have used any deception or deceit in previous applications, which is also similar to immigration offenses, then the Home Office will hold that against you. So you need to be a person of good character, whether you are the main applicant or a dependent. And the children over the age of 10 years, if they've got criminal convictions, then they might not be able to get their indefinite leave to remain or a settlement. You will also need to pay for the indefinite leave to remain or a settlement. So the fee is 2,885 per person, and there's an enrollment biometric enrollment fee if it is applicable. Some people will do it on their app or on the phone. The Home Office would prefer you to do it on the phone using an app if you've got a gadget that can access, or you've got certain minimum requirements for it to be able to download the Home Office app for that. There is no immigration health surcharge if you're applying for settlement. So you don't pay for the immigration health surcharge when applying for settlement, and you don't pay for the immigration health surcharge if you are now applying for citizenship as well. The other question that I got asked was about the dependents, if they came after the main applicant, or how long are they supposed to be in the UK before they can apply for settlement. Anyone who is a skilled worker or their dependent needs to accrue the 5 years before they can get the indefinite leave to remain. So if your dependent came after you a year or two after, or whatever period they came, then they will need to accrue their own 5 years before they can get indefinite leave to remain. And they also need to comply with the immigration rules For example, the 180 absence rule that I spoke about. And if they are adults, they need to pass life in the UK and English requirement. As you can see, settlement is quite expensive. So you might need to stagger it if you're going to do it depending on your funds. So you might have the an applicant apply first and the adults and then the children later and so forth. But it's something that you will need to discuss with your legal practitioner or your lawyer or a solicitor. If you've got any questions, I just put them in the chat and then I'll be able to pick on them so that I can respond to those questions. So please put on the questions and then I'll be able to speak to them, to respond to them. I've got only 2 points that I need to point out before I can conclude, unless if I've got any further questions that are coming through the chat. If a dependent came to the United Kingdom when they were still a child, and now they are over 18, they can still qualify for indefinite leave to remain as a dependent as long as we can prove that they are not living an independent life. They need to show that they are still dependent on their parents or on the skilled worker. So, for example, they are still staying in the same household, they are not married, and so forth. So, they will need to prove that they are still dependent on their parents. It could be that they now in a university or they are working. That doesn't necessarily mean that they are no longer dependent on their parents, as long as particularly we can prove that they have got the same connections such as their address and so forth. So they must have entered the United Kingdom as a child, having lived 5 years in the UK continuously as a dependent, not leading an independent life, e.g., married or living separately, meet adult indefinite leave to remain requirements, having passed life in the UK and English test for them to get their indefinite leave to remain as a dependent, even if they are over 18 years old. So, what is the impact of staying outside the country for when it comes to indefinite leave to remain? So, if you are outside the country for a reason connected to your job, that will not count against you, particularly if it is a British company, that will be counted as presence in the United Kingdom. But if you're outside the UK on any other reason, then you do not need to exceed 180 days in any 12 months because that will break your continuous residence. And the 12 months are counted every 12 months in the 5 years. So 12 every 12 months, so for 12 times 5 months. So for every 12 months, you don't need to be outside the country for more than 180 days. Otherwise, you will not qualify for indefinite leave to remain or settlement. There is a potential refusal of indefinite leave to remain application, and you may need to restart the 5 year qualifying period if lived for a long period outside the country, particularly for the um, dependents as well. So if they are going to accrue their period, they need to be in the UK. Of course, there would be exceptions, and this will require substantial evidence as to why you were outside the country for more than 180 days in every 12 months cycle, such as the reasons that I've pointed out. There was exceptional circumstances such as COVID, or you're working for a British company, and so forth. Each case depends upon its own circumstances. So another question that I've received is if you've got a warning for property damage, will this affect indefinite leave to remain? If it is just a warning and you have not been taken to court, you don't have a conviction, you don't have a county court judgment against yourself, then it will not necessarily count against you because it's not a breach of good character if it's not a conviction or if it's not a court order against yourself. However, the Home Office might also look at other things if there is a propensity in your character to breach the law, even if it's a low profile criminal activities that you are doing. But if it's habitual that you are doing, then you might face the challenge that the Home Office would say you are a person who's got a propensity to commit offenses or to breach the law, you don't respect the law, and so forth. So you need to make sure that you try to live as a good citizen in the United Kingdom. So I do not have any further questions, and thank you so much for those that have tuned in. If you have got any further questions, you can contact us on the contact details that are showing on the screen, and you can also subscribe to our YouTube channel, and you can also like our Facebook page so that you can get more information from us. Thank you so much.